everyone, this is Norm O'Neill with Keller Williams Realty, and today I've got a great guest joining me. I've got Kathryn Swain with McCandlish. She is a local attorney. We're going to talk about probate, estates, something that comes up a lot in my real estate work. Kathryn has a ton of experience in this area, and I'm really looking forward to the conversation. Let's jump right in.
Norm,
Yeah, definitely. Take a minute and introduce yourself.
I'm Kathryn Swain. As Norm said, I'm an attorney with McCandlish Lillard. We're in Fairfax and Leesburg, Virginia, but I do estate planning, estate administration, which is the post-death work, and then guardianships, conservatorships for incapacitated adults.
Wow, that is a ton. Thank you. Can you tell me a little bit more about why it's important to have these conversations before a crisis or a passing happens?
Well, really at that point, it's too late. So at that point, we're just picking up the pieces. We're trying to come away with something when the plan wasn't in place to begin with. And a lot of times that can lead to family issues, conflict in the family. A lot of times there's extensive legal fees if there has to be a trial on what the person intended because they didn't set up a good plan to begin with. So even though these conversations are difficult and, a little bit morbid to come into an estate planning attorney's office and plan and speak about your death, it's really so necessary to do that before anything happens, because then you can put it aside. You can stop thinking about it. You've got your plan in place and it's kind of off your shoulders.
That's also got to be a relief.
Mm-hmm.
Switching gears just a little bit, I'd love to, talk with you a little bit about estate planning and estate planning for homeowners, because part of this is what I'm hearing you say is so important to communicate with your attorney and get these plans in place before an event. And for homeowners that have lived in their home, say like 30 or 40 years, what documents do you recommend that they should have in place to make things easier for their family later?
Well, for any person, we'd want to make sure that they have a will or a trust in place. That's the document that's actually going to dispose of property after death and determine where property goes. We would also suggest that anyone over the age of 18 should have a durable general power of attorney, which is the financial power of attorney. That exists during the person's lifetime, and it appoints an agent to step into their shoes, make any decisions with regard to their finances and assets on their behalf if they ever can't. And then also an advanced medical directive or healthcare power of attorney, which allows them to appoint an agent to make those decisions for healthcare purposes. If that person's also a homeowner, then they certainly want to specifically plan for their real estate as well. So they can do that within their distribution document, either the will or the trust, where they specify who gets that property. If they set up a trust, they'd want to make sure that they actually move their real estate into the trust after they set it up, because otherwise the trust is kind of just an empty bucket for assets where nothing's, in there to be passed according to the terms of the trust term. So when we're setting up an estate plan for someone, we can create that deed that moves their property into their trust, and then it can go according to the terms that they set up. If someone instead has more of a will-based plan or a plan that doesn't involve a trust, we would suggest that they do a transfer on death deed, and that is something that avoids probate. It gets that property to the person who's named on the transfer on death deed as a matter of law at the moment of death. So both of those things provide for the passing of the property after death. With the financial power of attorney and other similar documents, they can also provide for someone to step in and make decisions about that real estate if they're alive but have lost capacity and something needs to be handled with regard to the property.
Wow. As you're saying that, it feels so like everybody needs this,
Absolutely. Yeah, it's something, unfortunately, it's coming for all of us. So all we can do is plan, get a great plan in place, and then again, not have to think about it again.
Yeah, these are the kind of things you don't really want to think about at all. So it helps to go through it with a professional and then get through it as fast as you can, maybe.
Absolutely. And there will always be updates in the law or updates in someone's family that may trigger changes and reassessments to the plan. But generally, once it's there, it's not something that needs to be dealt with, at least on a regular basis.
Yes. That sounds like a relief.
Absolutely.
We've talked about wills and probates. Can you tell me a little bit about a trust? What is the benefit of a trust, and maybe how is it different than maybe a planning by will?
So one of the big differences is that assets that pass pass through a trust do not go through probate at all. But wills, if there are probate assets, meaning there are assets just in that individual's name, so not owned with somebody else with rights of survivorship, not an asset that has a transfer on death designation, like payable on death or TOD. If it's just in that person's name with none of those designations, that's a probate asset, and it will go through the probate process even if a will is in place. And what we were just talking about is, the downside to probate. It can be lengthy, there are probate taxes and fees, and whoever is appointed to deal with the estate under that will has to do regular reportings to the county commissioner of accounts. So they would file an inventory, they would file regular accountings. All of those filings have fees associated with them, and they're really not user-friendly or easy to understand, how to create those inventories, how to create those accountings, what forms to use, how everything should be laid out. So it's a really difficult process, especially when a loved one is grieving you and they're trying to settle all of your affairs and then do this court process. In Virginia, we don't have a separate probate court, but the circuit court does supervise the probate proceeding, and the commissioner of account ultimately supervises how an estate is managed. But on the trust side, as long as the trust is properly set up and assets are placed into the trust, we call that funding the trust. If the assets are moved into the trust during the person's lifetime, then they pass without any of the need for that probate procedure. So the individual can set up whatever bells and whistles they want on their trust. For example, if they have minor children, they may want to hold distributions for those minors in continued trust till they're 18 or even 21, 25, whatever age they feel is appropriate, because sometimes they're mature enough, whether it's age related or for another reason, to actually deal with that. So that's one of the major differences. The other difference is that trusts are set up and funded during the individual's lifetime. So if that person ever loses capacity, even though they're still alive, their successor trustee can jump in and manage the property for them so that they don't have to go through a court proceeding for guardianship and conservatorship, which is a public declaration of the person's incapacity just to get a decision maker in place, for the judge to appoint. So it really does make things simpler on both the incapacity and the after death side.
I see what you're saying. If you value your privacy and things of that nature, this is a great step, as life happens.
Because the probate procedure is all public. So any will that's being probated can be looked up. You can see exactly who got what property. And a lot of people are uncomfortable with that if they have minor children, if they have special needs beneficiaries, or if they just don't want that, publicly available with all of the scammers and the AI issues we have today.
Oh my God, you said it. You said it, Kathryn. As you're talking too, I was curious if a property passes through a trust and then the trust sells it. Does a stepped-up basis come into play there, or?
Yes, so as long as the property is transferred after death, then it's a non-issue. And a lot of people set up what are called revocable living trusts. They put their property into the trust during their lifetime, whether it's their personal property or their real estate. And then at death, that transfer happens where the beneficiaries that they've named receive the property, and they've got that stepped-up tax basis as of the date of death of the original grantor of the trust.
Oh, I love that. So even if it's in a trust, you still get the stepped up basis.
Absolutely.
Got it. Just so I know, or I'm sure a lot of people are curious, once you put something in a trust, like you put your real estate in the trust, and let's say interest rates come down, and I want to refinance, does that make it more complicated that now my home's in a trust, and I want to get maybe a refinance started?
There's actually a law in place that governs this. It's called the Garn-St. Germain Act, and that says that you're not required to pull that property out of the trust, to sell it, to refinance it, to do any action with it. So it should be completely streamlined, and there shouldn't be any complication with having the property in the trust. With that being said, everyone's dealt with a difficult, company, closing company, title company, whatever it is.
Yeah.
And if the property for their purposes needs to be pulled out of the trust for a sale to happen, it's an easy deed of distribution to pull it back out. But otherwise, the property would be dealt with as trustees. So the person managing the property or managing the trust is called the grantor. They set up the trust. It's their own property. They're also the trustees of the trust. They continue dealing with their property as they normally would. They're just signing off as trustee on any transaction they make.
Oh, that's great to hear. Tell me about this. How could a realtor and estate attorney somebody like yourself work together to make sure a client's home sale aligns with their estate plan?
Well, first of all, the estate planning attorney could advise on what the documents actually say should happen with the real estate. If we're in that scenario where the administrator doesn't have power of sale and the property needs to be sold, then the attorney could help to get that authority from the judge, in a court proceeding. But also the attorney can work with the real estate agent to make sure that those provisions we talked about are actually in the documents, that the property is sold as is, that there's a special warranty deed, that all of that is in place so that the individual is not taking on more liability. Because this is something that some people don't ever do, even in their personal lives to sell their own property, but certainly a lot of people don't take action as a fiduciary and sell property out of an estate just every day. And so to have kind of that peace of mind that there's not only an attorney, but a real estate agent also working together to safeguard their interests and make sure they're completing the proper steps is huge.
I couldn't agree more. I'm sure you see it all the time. When we're working with our clients, they have so much of life happening and so much of it is new to them that it's really nice when we can walk alongside them and take something off their plate or just smooth out a rough edge and allow them to move forward with their day,
Absolutely. And sometimes people are appointed who don't even live in Virginia. So they may be in their state. They're trying to deal with, again, their own life, but then they have to deal with Virginia law, Virginia procedures, fiduciary procedures. I mean, it's a huge burden to take on. And so having trusted resources is very ideal.
I love the way you put that. Trusted resources. Exactly. Can you give me an idea of what it typically would cost to set up an estate plan or to handle a probate case?
An estate plan, it's a lot cheaper than dealing with a probate case gone wrong. So a lot of people don't want to spend the money up front. They either want to have, nothing in place, or they want to download a free will template on the internet.
Sure.
And usually those always end up something is either, contested and we have litigation, or something was misconstrued and we don't have the person's intent. So then we have litigation as well. On the front end, it completely depends on the person's circumstances, whether they're married and this is a family plan or a single individual. But it can be anywhere from $2,000 to around $5,000, depending on complexity. I would say that's a general range. We can go, above or below based on that person's needs. But if there's estate litigation and the matter has to go to trial, this can get up to $25,000, $35,000 or more easily. And that's assets that are coming out of the estate. So it's much better, although it always hurts to spend that money, on the front end, but to get a good plan in place so that you're not spending much more on the back end.
Yeah, it sounds so preventative. You're going to save money on the back end. You're also going to save time, headache, grief. It makes a lot of sense. What's one thing you wish every homeowner knew about estate planning?
I would say that non-action is an action. And so by waiting and by thinking, well, I don't know what to do with my real estate, I don't know who should get it, or I don't know how to set that up, you're actually taking an action. You're leaving this open to a bunch of problems down the line, potentially. So it's kind of like going to the dentist, going to the doctor, things off the to-do list, and they may be uncomfortable or not the best thing on your schedule that week, but taking that action is really the first step, and it's so important with an asset as valuable as real estate.
Oh my gosh, that's fantastic. Thank you. So, Kathy, tell everybody what's the best way to get in touch with you, and are you on email, or what's the best way for people to reach you?
Absolutely. So I'm sure we'll post my information here. My direct line is 703-934-1111. Easy to remember. So feel free to call me, and also email. My email will be posted, but I'm happy to talk to new clients all the time. I don't charge for consultations. I want to be able to give that information and have the person, discuss it and evaluate it and not feel like they're up against the clock when they ask me questions.
Kathryn, just by you saying that makes me want to call you, so we can, this is exactly what our clients are looking for. Professional advice, and it kind of on their schedule almost.
Exactly. Yes. This is a personal thing. It's something that someone needs to fully understand and completely agree with, and not just get a pile of legalese, whether it's a trust or a will, but some document that they don't understand and it may not reflect their true intentions. So it's really important to me to sit down and meet and talk through all of their family, relationships, all of the issues that they're trying to plan for, and then come up with the best approach that's really going to suit them.
Oh, that's great. That's great. That's why you're doing an excellent job for your clients. I appreciate you being here and joining me for this video today. It's been super informative for me. I know that so many folks have been looking forward to the video, so I'm looking forward to sharing it with them and getting this good information out there. I'm Norm O'Neill, local realtor with Keller Williams Realty. Remember, questions, concerns, hallucinations, call Norm.